Case to be argued this morning is City of Akron versus Breyana Burch, case number 29024. Attorney for Ms. Burch, Mr. Decado, waived his argument, so Mr. Bremer, you will have 15 minutes.
Thank you, Your Honors. Good morning again. You'll be seeing me a lot this week. I have another one on Thursday. Again, good morning. I'm Brian Bremer, here on behalf of the City of Akron. This case is a suppression case. The prosecutor's appeal from the trial court's decision granting the motion to suppress. The trial court found that the Officer White did not have probable cause to believe that the defendant, Breyana Burch, had been operating a vehicle while intoxicated on the evening in question. The trial court was incorrect on that fact. The officer had a plethora of evidence and facts available to him that would indicate, to at least to the extent of probable cause, that Ms. Burch was intoxicated when she operated her vehicle. Officer White went to dispatch the scene of an accident. When he arrived on scene, he saw Ms. Burch being treated by EMS, and he saw her car upside down in the road. He went and checked on Ms. Burch to see how she was. She had glossy eyes, she had slurred speech, and when he asked her if she'd been drinking, she said that she had a Long Island iced tea that evening. The officer then left her with the EMS workers and went and investigated more about the accident. He saw that it was a single car accident. There were skid marks that indicated a high rate of speed. She had gone left of center into a median that was grassy, gone through a light pole, and flipped her car upside down as a result. The officer...
Counsel, sorry, I'm choking. As to the initial glossy eyes and the trial court and I guess appellee make much of the fact that the officer testified that he did not immediately attribute that to her being under the influence. How do you respond to that?
Well, I think that actually goes to the fact that the officer was doing his job correctly. He showed up on a scene of an accident, and the first thought isn't, well, it must be DUI. Like he didn't go in with preconceived notions. He saw someone injured, and he thought that could be the result of those eyes. The eyes could be glossy, and like the slurred speech could be because of an accident. But the officer investigated further, which he should do, and in this case, learned that she had been drinking, which he found out after he observed the glossy eyes and slurred speech, which, you know, because it said when he first saw her, he did not think immediately DUI, but then she told him that she'd been drinking. Then he went and investigated the accident, saw it was a single car accident, and also it was 2 o'clock in the morning, and when he returned to speak to her again, when she was in the back of the EMS vehicle, he noticed that she smelled she had a moderate odor of alcohol coming from her.
At any time did she indicate she was on her cell phone, fell asleep, she was texting or anything?
No, Your Honor. The appellee raises a number of different possible explanations for what could have caused this crash. You know, she could have been recklessly driving while on her cell phone. She could have been recklessly driving while on her, like, messing with her radio. She could have fallen asleep. But there's no evidence in the record for any of that. It's all pure speculation. And on top of that, officers aren't required to actually go through and eliminate every possible explanation before they have probable cause. The United States Supreme Court settled that issue this year in Wesby. They said that all you need is to have a reasonable belief. You can't believe facts that are false, but you don't have to go and run down every possible explanation before you can arrest someone for a crime. That's part of the reason why it's only probable. Probable cause is only going to the level to warrant a reasonable man in the belief that a crime has occurred. In this case, whether she had operated a vehicle while intoxicated. When he spoke to her in the back of the EMS vehicle, he noticed that there was a moderate odor of alcohol, so now he had another factor to consider, and she told him she had 4 shots. And the appellee and the trial court seemed to make a bit about the idea that the officer admitted on cross, I don't know if she had 1 drink with 4 shots in it, or she had a drink and 4 shots on top of that.
And it would have affected her system differently. How?
That is our position, Your Honor. Even conceding the fact that maybe she only had 4 shots of alcohol before getting behind the wheel, that is still a fair amount of alcohol to consume, especially when you mix it with the late hour, the single car accident itself, and the glossy eyes, slurred speech, odor of alcohol. And then the other thing the officer had was when the EMS workers took her away from the scene of the accident at that point. He stayed, helped clean up the accident, or oversaw the cleanup of the accident, and then he went to the hospital, which was a fair amount of time later. And it's not entirely clear from the record, but it seems like it was about an hour before he got to the hospital to speak with her again. And she still smelled of alcohol an hour later. And at that point, the officer said, the officer decided to arrest her at that point. But he had enough to arrest her at the scene of the accident. He just chose not to, given the fact that she was going to the hospital to be treated, or any other number of reasons. But he had probable cause at the scene of the accident. And the fact that she still smelled of alcohol, like at least half an hour, possibly an hour later, that would indicate she probably consumed a fair amount of alcohol when she had been when she was driving her car. So in this case, the officer had a plethora of evidence before him to indicate that she had been drinking, and the record itself really establishes that he had probable cause. So for that reason, we would respectfully request that you reverse the decision of the Akron Municipal Court on this matter and remand for further proceedings.
Questions? All right, thank you very much for your argument.
Thank you.
We will, of course, take the matter under advisement, and the court will issue a decision. You will receive a copy of that decision on the day it's released, and it will also be posted on the Supreme Court of Ohio's website.
Thank you.
That's it for you today, right?
Yeah, it is.